72 amendment.
Yes.
That brings out, what exactly happened. It appears that there was student unrest on the campus.
Yes.
At that point, they brought in a temporary measure.
Yes.
The idea was to bring both Aligarh Muslim University and Banaras Hindu University at par in terms of the statutory provisions.
Right.
UGC appointed a commission chaired by Dr. P.B. Gajendra former Chief Justice of India, to go into the functioning of AMU. That Dr. Gajendra submitted his report. We may have we may want to look at the report which was submitted by Dr. Gajendra
Sure.
On what did the report really indicate.
Right.
Following which, but the 1965 amendment was always intended to be a sort of a pro tem amendment until long-ranging amendments were brought into the provisions of the statute.
So then, Maharaj, between 65 and 81, I go back to my list of dates, Maharaj, the point of which is that volume 4.
See if you look at
note, yes. So, Maharaj, we come to 1965 and the decision in 1968. Then between 68 and 81, there was a movement to protect the rights of Aligarh Muslim University as a minority institution. And then the 1981 Act came. So you have a hiatus between 65 and 91, Maharaj. 68 and 91.
Just give us the page number of the 1981 Act so that we'll have it all in one place now. Volume 4A.
4A. Volume 4A, Maharaj.
Page
147. And Maharaj, in that context, if your lordships don't mind, that that judgment is not on record. Yeah. There's a judgment of this court in 1998, 6 Supreme Court cases. This court which is on your lordship's screen, Maharaj. 1998, 6 Supreme Court cases, page 674. Kindly come to 679.
679, Pajari.
679. This was in the context of a minority school, Maharaj. Maharaj, minority school in paragraph 11, Maharaj, your lordships will see, is defined in 2.5 of the Act. Minority school means school of their choice established and administered or administered by such minorities as have the right to do so under clause 1 of 30. Counsel for both sides conceded that there is no provision in the Act which enable the government to declare a school as a minority school. If so, a school which is otherwise a minority school should continue to be so, whether the government declared it as such or not. Declaration by the government is at best only a recognition of an existing fact. This is very important. Article 31 of the Constitution reads as such, I won't read it, Maharaj. When the government declared the school as a minority school, it had recognized a factual position that the school was established and is being administered by a minority community. The declaration is only an open acceptance of a legal character which should necessarily have existed antecedent to such declaration. Therefore, we are unable to agree with the contention of the school that the school can claim protection only after the government declared as a minority. We are not dependent on the declaration, Maharaj. It's what happened antecedent to the declaration that will determine whether it's a minority institution or not. So whether the minister says it or the statute says it, none of that is relevant. What is relevant is the factual position existing antecedent. We come to the 91 Act, Maharaj. Your lordship is aware of that Act. Then comes, Maharaj, on 26th of November 1981, there's an order passed in Anjumane Rahmaniya, which is writ petition 554 to 57 of 81, which is referring Basha's judgment to a 7-judge bench. That's on November 26. This is important. That is November 26, 1981. The 1981 Act was on December 22nd December 1981. Just 1 month after this. Yes, was 22nd December. Now, Maharaj, kindly look at that order of Justice Fazal Ali.
Fazal Ali Ji was in a bench of 2 or bench of 3? 2.
So this happened, Maharaj, in November 81. The Act comes on December 22nd, 81. In the meantime, on the ground, nothing has changed, Maharaj. When Chagla made that speech in Parliament, he didn't implement the 65 Act as Maharaj was sought to be done. He didn't do it, Maharaj. Only instead of all it being packed, only 3-4 members remained of the non-Muslim of nominees of the government. Then, my lords, that is the Old Boys Association, which was set up in 1899, started a whole movement that, look, this is all wrong. This is all wrong. You must have an act. That's how the act came into being. And, my lords, I mean, I don't want to digress into any other issue, but the fact is that this is a pre-Constitution Act. It's a 1920 Act. Without going into usurpation of judicial power, my lord, that's all, according to me, an irrelevant issue. Under 372, an act can be repealed, altered.
One act,
Yes.
did that have the effect of therefore then nullifying the 65 amendments?
Yes. Yes. Absolutely. So this whole argument of usurpation, the Constitution gives the Parliament that right. But I don't want to argue it because it doesn't arise in Bhasha. But since,
Basha involved a challenge to the 65 amendments.
That's right. And 51.
And 51.
Yes.
And the 1981 Act then restored the position by, I don't know whether it
No,
destroyed
no, it
it,
didn't
but
exactly restore. It was a new
exactly
legislation.
restored, but it nullified the effect of the 1965 amendment.
That's correct. But Mala, that doesn't matter because the 372 gives power to Parliament to alter a law.
If we, will it be correct to say?
It seeks to nullify the judgment.
No. That's not true.
I'll show. I'll show.
Will it be correct to say that in case we overrule Basha, then the challenge to the 65 amendments will come into the foray?
No, Malas, the point I'm making is in somewhat different, Malas. We are challenging Basha on the day when it was decided, therefore none of this is relevant, according to me. Because the reference is only whether Basha was rightly decided on the day it was decided. That's the reference. But all these matters are now being brought in by the other side. All these matters saying it's an institution of national importance. What to do is whether Basha is rightly decided or not. On the parameters of the law under Article 30. What your lordships are not asked to decide. Now they have brought in entry 63, it was not argued in Basha. Are we to argue something else now? They brought in statutes that are minority statutes that are normal institutions that are now incorporated under the National Minority Commission Act. Are we to look at that? That's all irrelevant. Wholly irrelevant. This is a decision of 1968 based on an act of 1920, which your lordships are asked to decide whether it's right or wrong. Otherwise, there'll have to be pleadings because he has made some amendments which are completely wrong. But you can't have pleadings in a reference. He's giving all kinds of examples. Land was given is completely wrong. But we are not into that. That's why I'm not arguing any of that. That's why I'm not even meeting that argument. But that whole argument is sought to be diverted to issues which are not before Basha, issues that don't arise under the 1920 Act.
All right, what else?
So, Manas, I'm quickly trying to go through it. So, Manas, no. Then what happened was, just Manas, kindly. I'm trying to, Manas, finish as quickly as possible.
Mr. Sibyl, just one simple question.
Yes.
Did Dawoodi Bohra make it applicable prospectively, the principle laid down in Dawoodi Bohra? Or is it applicable retrospectively?
I'd have to, Manas. I don't want to answer that question. I don't want to answer that question right away. I don't want to answer that question right away. I will certainly, Manas. So, Manas, what happens thereafter? And that's then comes Manas. Then comes TMA Pi. Now, this 54 writ petition 54 to 57 is tagged on to TMA Pi before 11 judges.
The order also says that.
That's right. So, Manas, this whole argument that you couldn't refer it, two judges could not refer it, of course, Manas, the principles of law at that time are different. But be that as it may, Manas, it was tagged on before 11 judges. Writ petition 54 to 57, you'll find that order, Manas. Court rules, Manas. It says, where in the course of a hearing of any cause, appeal or other proceeding, bench considers that the matter should be dealt with by a larger bench, it shall refer the matter to the Chief Justice, who shall thereupon constitute such a bench for the hearing of it. Rules, Manas, order 6, rule 2.
And rule 1 anyway preserves the power of the Chief Justice.
That's correct. And Manas, even Justice Gogoi's reference was 3 judges, Manas. Even Justice Gogoi's reference was 3 judges. So this objection that, it can't be referred, Manas, is all.
And though Chief Justice Gogoi was sitting on the judicial side,
Yes.
As Chief Justice, his powers are
His
preserved by
powers
all
are
the
there,
fixed
Malad.
rule one.
Yes.
to constitute
And then
larger
PM
bench.
If bench consists of the Honorable Chief Justice, it can be.
Why can't why can't two judges say refer it to 7 and refer the matter to the Chief Justice?
Anyway, but I'll not reduce the debate to that level.
No, but
I'm not going to
taken
raise that.
objection.
We have addressed your lordships on merits. I will also.
Correct, because initially he did, therefore I.
The matter is too important for us to really
Yes,
rest the judgment. on
exactly.
it.
Yes, yes, sir. What I initially
So,
said
we
was.
can't be oblivious of the fact, reference of 1981,
Certainly.
tagged on to 11 judges,
Certainly. But I'm-
left open in PMFI.
Yeah.
Then noticed in Justice Gogoi in the referring order of 2019. But Mr. Sibal, there's one which
One
we
thing,
must
Malad, I
also
mean-
bear in mind.
Sure, sure.
That when Chief Justice Gogoi's bench made that reference to a larger bench in 2019, unless.
No,
I have not raised it.
Then,
I'm not.
then the pleadings are incomplete. Then there are no pleadings to this effect.
But we have for instance, we have a parliamentary amendment of 1981.
Correct, but there are no pleadings for
That I will show from the record.
will it be decided?
It's whatever I have said is a part of the
Clear on
record.
one thing, Malad.
Only one. Give me a minute, just to answer the court. I have not raised that technical point. Initially, I said that the scope of reference is not redeciding Basha on facts which are concluded. The way they are arguing, that's what I have said.
No.
I have
In
not-
fact, Malad, he said that's an inter-parties decision. It cannot be altered by a bench. That's his argument.
That's
in the written
But not this,
summation.
the reference could not have been made.
One
as
second, one second.
Yeah, Mr. Sibal, Mr. Solicitor, we are in a combination of 7.
Yeah.
We decide a constitutional matter. Perhaps it would be inappropriate for us to look at facts for deciding the
Yes,
minority
yes,
character.
yes.
Who gave how much land, who,
Yes.
whatever is already on the record, what was brought on the record in Badshah, what is
And Allahabad High Court, whatever is in the record from the Allahabad High Court, no problem.
So when we hear Mr. Parasad's de jure versus de facto argument, we must also keep at the back of my mind that this is a constitutional court
Yes.
sitting in a reference of 7.
That's right.
So we really have to, in that sense, confine ourselves, and perhaps there's always a temptation to try and resolve everything forever, but it's difficult, and we should be careful about doing that in a combination of 7, particularly in the absence of test facts.
My request is whatever pleadings are available in the Allahabad writ petition should be taken into account.